Good morning, everyone. We're just waiting for people to log in. I see the numbers going up, so we'll give it a few moments just before we start. Just give it another minute. I see the numbers have plateaued, so we'll just make sure nobody's having any issues logging on, and then we'll start. Right, looks good. Right, good morning all. Thank you for joining us today for the Boys Turner annual privilege update. My name is Phil Baldwin. I'm a partner in the dispute resolution team. I'm also joined by my colleague Annabel Barons, who is also a solicitor in our dispute resolution team. For those of you that don't know about Boys Turner, we're one of the largest firms in the Thames Valley region. We're based out of our office in Reading. We're a firm that provide a full range of commercial legal services. We have leading individuals in sectors of tech, innovation, leisure, and hospitality. So moving to the actual webinar today, this is the annual privilege update. It is going to be an update on some recent case law, going over a very well-known case law that's already in place, and also a general refresher for everyone in respect of legal professional privilege. I'm very grateful we have a lot of people on the line today. But given how many people we have online, we won't be able to answer any questions during the seminar. But what we do have is the question function. So if you do have any questions, please use the feature on the Zoom call. Alternatively, at the end of this seminar, you'll have my email address, also Annabel's. Please feel free to reach out to us directly, and we can try and answer any questions. So hopefully it will be informative. I say it will touch on the basics. It will revisit some previous case law, as well as some new cases that have come to light over the past year. There'll also be hopefully some helpful tips for in-house lawyers. Right. This is a slide, say just pictures of myself and Annabel. So let's move into the webinar. So privilege, just a quick overview. It's a fundamental right allowing a partner, which includes successors in title, to withhold from production certain documents. And they, of course, include communications between lawyers, sometimes third parties, for example, experts, and their clients. Just because a document is privileged doesn't mean that you don't have to document its existence. For those that have dealt with litigation before, you normally confirm that the document exists, but that you claim privilege over that document, and therefore you're not going to disclose the same. It is a special protection that enables a client to retain confidentiality in respect of communications with their legal advisor. Now, the umbrella term is known as legal professional privilege, and it is a central principle to the administration of justice in England and Wales. Within legal professional privilege, it's a term that includes both legal advice privilege and litigation privilege. And we're going to touch on both of those today and some of the relevant case law that is relevant. There has been a very recent case in the Employment Tribunal of University of Dundee versus Chakraborty. Now, this sets out, and I think it's helpful to say at this stage, that in respect of both legal advice and litigation privilege, privilege will be decided at the point of creation. It's not a case that you can attain privilege of a document at a later stage, even if litigation then happens in the future. So it's when that document or communication was created that the courts will look at. Right, moving to legal advice privilege, and I'm well aware that people know what this is, but it's always helpful to have a general refresher. It is confidential communications between a client and a professional legal advisor or in-house lawyer for the sole or dominant purpose of giving or obtaining legal advice. Now, there are some difficulties in respect of the definition of client, and this is prevalent in, for example, your businesses. If they are large companies or, for example, financial institutions, then that definition of who the client is, whether it's the board of directors, whether it's the CEO, can be difficult. I'm pleased to say that advice from in-house counsel is covered as long as it's given in the relevant legal context and relates to the legal part of their function. We'll come on to that because I'm well aware that a number of in-house counsel that I have met do sit on the board or advise the board, not just for legal purposes, but also from a management, compliance, or general commercial view. I think we just need to look at who is deemed a legal advisor. Now, legal advice privilege will only apply if one of the parties is a lawyer, and in limited circumstances, there is a carve-out by statute. That includes, for example, trademark agents, patent agents, and license conveyors. We do also need to be careful as to accountants. I know in my private practice, you see regularly accountants trying to give legal advice in respect of, for example, tax issues or other issues that may arise. They will not be able to benefit from legal advice privilege. So be careful with those communications and discussions with your appointed accountants. So who is a lawyer for the purposes of legal advice privilege? Some of the considerations, and there are lots that we should consider, is that it does cover all members of the legal profession. So this is solicitors, barristers, in-house lawyers, trainee solicitors, and pupil barristers, to name a few. It also applies to junior colleagues to whom work is delegated. I'm sure within your legal function, you may delegate work to junior paralegals or legal assistants. So we need to bear that in mind. It also covers senior lawyers consulted on particular issues. And it will also apply to foreign lawyers, whether or not they're in-house or standalone. Right, focusing on in-house lawyers. Of course, legal advice privilege is available for in-house counsel, provided that the advice is given in that relevant legal context and relates to the legal part of their function. The example here is it's truly for the purpose of obtaining or giving legal advice. Now, what won't be covered is, and I've touched on this already, advice that's related to things that aren't in respect of their legal functions. So management, compliance, or other broader functions of the business. It would also not cover people like compliance officers who tend to give advice of a legal nature. Again, or also noted accountants in that regard. HR officers also give advice of a legal nature, but don't fall within the definition of a professional lawyer. There are some exceptions that if that person is supervised by a qualified lawyer, so perhaps an employment lawyer is supervising an HR officer, then we could raise arguments that communications and documents are covered by legal advice privilege. One of the other areas is the purpose of legal advice. Just because a communication between a lawyer and a client takes place doesn't mean that all communications can benefit from legal advice privilege. The very well-known set of case law, Three Rivers, and just to note, we will provide these slides with the links to the relevant cases. The Three Rivers set of cases set out that legal advice privilege, all communications between client and the lawyer would be too wide. In order to benefit from legal advice privilege, the communications must provide advice as to what should prudently and sensibly be done in the relevant legal context. So the communications or the documents must directly align with the performance of the lawyer of their professional legal duty, or if you're in-house, your legal function of the business in order to advise the client, which could ultimately be the company or the board. Communications between lawyers and their client relating to the transaction in which the solicitor has been instructed will be privileged. This is notwithstanding that they may not contain any advice on matters of law. So it's important to note how and why the solicitor has been instructed from the outset. The relevant legal context, and we go back to the leading cases of the Three Rivers set of proceedings. The House of Lords set out helpfully what the court should ask. They should ask whether the advice related to the rights, liability, obligations, or remedies of the client under either private law or public law, and if so, whether the communications fell with the policy justification for privilege. Were the lawyers being asked as lawyers to provide legal advice, which sets out quite a clear definition of what is required. So just to put that into some sort of practical context for everyone, presentation of risk management advice would be privileged if given in the relevant legal context. A client's note of legal advice communicated to him orally would also be privileged. And this, the next point is always quite interesting. In private practice, I regularly see solicitors not acting as lawyers, but acting as is defined in the Kerman case, a man of business. There will be no legal professional privilege if the solicitor is acting as a man of business rather than undertaking their legal function. So on that basis, it's incredibly important for practitioners to distinguish between instances where an advisor is acting as a legal advisor or as a business advisor. So for those of you that do sit on the boards or management committees, you need to be alive to that fact. Simply the preparation of minutes by a lawyer in a meeting doesn't automatically give them legal advice privilege. There has to be some sort of function connected with the giving of legal advice. So don't fall foul of that. By simply taking the minutes doesn't mean that you can rely on legal advice privilege. Also, it must be possible to see from the document, either directly or by inference, a statement of privileged advice or communication. So there needs to be that legal advice present within the document to be able to rely on legal advice privilege. Another case, the Property Alliance Group versus the Royal Bank of Scotland PLC. This is in respect of the continuum of communications, and the exchange of information between the lawyer and the client could be covered by legal advice privilege where they were provided, so that advice could be given as and when appropriate. Essentially, the lawyer has to be able to provide their client with factual briefings of investigations and communications, and therefore they would be protected. There are some, so the final point of that slide is quite interesting. The judge applied principles set out in the case there, namely that where the contested documents would reveal a clue to the advice given by the solicitor, or that they would betray the trend of the advice which the solicitor is giving the client, then the documents are privileged and cannot be inspected by the other party. Moving on to the dominant purpose. So legal advice privilege may only apply where the dominant purpose of the communication is to obtain or give legal advice. And in the case, the 2020 case of rjet2.com, quite an interesting case, and I'll go into it slightly further on the next slide. It was set out, especially for in-house lawyers, and it stated as follows: lawyers, particularly in-house solicitors, may often take part in general business discussions which do not involve legal advice. Where the in-house lawyer is clearly being asked for legal advice, privilege is likely to attach. However, where the in-house lawyer is being consulted also as an executive about a largely commercial issue, then the dominant purpose test will fail to be applied. So that dominant purpose must be to obtain or to give legal advice. Your discussions at, say, board meetings as to commercial issues simply will not attract legal advice privilege. We'll continue with the rjet2.com case, which I think is quite relevant. I know it's relevant in a large private practice, but also relevant in your larger corporations. In this case, an email was sent to multiple addresses, which happens quite regularly, of which some were lawyers and some weren't lawyers. The court was asked as to the position of legal advice privilege, and they applied that dominant purpose test, namely whether the communication was brought into existence with the dominant purpose of it being used to obtain legal advice. Helpfully, privilege is not lost merely because non-lawyers are copied into an email. Privilege can be maintained when non-lawyers are copied in or legal advice is sent in this way. But of course, it could lead to many challenges as to privilege. So in order to protect yourselves and the company, we have to be, we should exercise caution when circulating communications to mixed groups of recipients or a very large amount of people on those chains of emails. Something to watch out for everyone. Legal advice, I'll just sum up the dominant purpose point, is that if the dominant purpose of the communication is to seek advice from the lawyer, the email or document would be privileged. If, on the other hand, the dominant purpose of the communication is to seek, say, a commercial view on something, and even if lawyers are copied in, then the communication would not be privileged. I also want to touch on jurisdiction. I'm conscious that some of the people here today will have offices in other countries, and therefore it could be relevant. In terms of jurisdiction, if the English courts are the venue for determining a dispute, the law of England and Wales will determine whether that document is privileged. The very recent case in 2022 of a Siam Commercial Bank dealt with what happens when a document is privileged in one jurisdiction but not the other. It was held that the fact under foreign law the document is not privileged, or that privilege that existed is deemed to have been waived, is irrelevant. The crucial consideration is whether the document and its information remain confidential in the sense that it is not properly available for use. If it is, then privilege in England and Wales can be claimed, and that claim, if properly made, will be enforced by the courts. Right, that's the end of legal advice privilege. Now, the second part of legal professional privilege is litigation privilege, something that I deal with quite a lot in my day-to-day caseload. Litigation privilege only arises in general in favour of the person who is a party to litigation. That litigation needs to be in English proceedings. The Three Rivers case, again, sets out that communications between parties or their solicitors and third parties, experts, for the purpose of obtaining information or advice in connection with existing or contemplated litigation. That is litigation privilege. Again, and I'm not to keep going in on accountants, but they regularly do provide litigation support and sometimes act as quasi-solicitors. They may not, they can benefit from litigation privilege, but both parties should be conscious that there are arguments that can be raised when the accountants are providing that litigation support. Most notably, it was set out in the case of Prince Geoffrey and KPMG. I know a lot of the top four accountants are now having larger legal functions, and I'm sure there'll be some crossover there in the future. Now, defining contemplation, in progress, and adversarial proceedings. The proceedings must be adversarial and must have commenced or must be anticipated, apprehended, contemplated, pending, or threatened at the time of the communication. So in short, there has to be a real likelihood that there is going to be litigation and not just the mere possibility. The Court of Appeal recently set out that the fact that there was a distinct possibility that sooner or later someone might make a claim was insufficient. So was a general apprehension of future litigation. So we can't simply rely on litigation privilege on the basis that it might happen or it could happen in the future. And what is important is in-house lawyers obtain evidence to show that there is anticipated litigation and make sure those notes are made as to why legal advice is taken and why certain acts were undertaken on the assumption that anticipated litigation of adversarial proceedings are likely to happen. A party can cannot simply assert that it's a possibility that proceedings are likely to happen. So moving on with adversarial proceedings, what do they include? They include court proceedings, employment tribunals, and arbitration. They can also include criminal proceedings and regulatory proceedings. And the Tesco's and OFT case sets that out. What adversarial proceedings don't include are disciplinary proceedings, grievance proceedings, inquiries of that nature. There is a carve out there, is that in some circumstances in which, for example, an investigation is undertaking, it can become adversarial. An investigation can be covered by litigation privilege, but again, we have to show that the dominant purpose for the report's production was adversarial litigation. And again, those notes are important as to why an investigation report was commissioned in some way. If the purpose of that report was in respect of adversarial litigation, then it's likely to be covered by litigation privilege. Something I see all too often is issues in respect of delay. The delay between the creation of a document or a communication and the issuing of proceedings will be taken into account by the court. We can't delay for huge periods of time and then suggest that litigation was in contemplation. Again, there should be notes written as to why delays happen and the reason behind that, whether that be a delay in instructing counsel for advice or a delay in issuing of proceedings. There needs to be some sort of explanation that can be provided to the court. Also, just to note that there's no distinction between the prospect of civil and criminal proceedings for these purposes. Litigation privilege also has that dominant purpose point. It will only apply to documents and communications with the dominant purpose of obtaining advice or use in actual or anticipated litigation. Now, the burden of proving that dominant purpose is on the party seeking to rely on the protection of litigation privilege. And this is why we go back to notes being made as to why or how litigation is anticipated and what the purpose of the advice or communications are. Just to note, documents and other materials created for more than one purpose can also attract litigation privilege. And the dominant purpose test is one to be decided by the courts objectively rather than by the parties themselves. They take into account all the evidence and therefore we need to have that evidence available to provide to the court if there is a dispute of that nature. As always, each case will be based on a determination of the relevant facts. Just a final sum up. In short, the courts will carefully scrutinise any witness statements filed in support of any privilege contention and will cross-reference with any such statement the contemporaneous material available. Elements within the contemporaneous documents which may persuade the court that there was a real likelihood of litigation at the time the document was created include retainer letters to professional advisors expressly stating their opinion or advice is being sought for the purpose of litigation, evidence that steps were being taken to comply with disclosure obligations and other items like that. So what is key there is that there is communications and letters with your professional advisors expressly setting out why you are obtaining legal advice and that it is for the purpose of litigation. And we need to make sure that those correspondence fall within the definition of the dominant purpose, the adversarial litigation, whether it be contemplated or anticipated. In respect of litigation privilege, quite an interesting case in respect of, or two cases in respect of SFO and the WH Holding Limited case. The Court of Appeal had decided that legal advice given to settle a case, reasonably contemplated proceedings, is covered by litigation privilege. So this is advice in respect of settling would be covered by litigation privilege. However, the case in WH Holdings Limited turned that on its head slightly and gave us further clarification. Said that documents created with the dominant purpose of discussing a commercial settlement of a dispute when litigation was in contemplation was not protected by litigation privilege, as the document did not reflect legal advice. So regularly we have commercial settlement meetings where we take the legal element out of the case and have discussions as to settling a dispute commercially for whatever reason, whether it be litigation cost or whatever. So we need to be careful that those discussions may not attract litigation privilege, because there is arguably no legal advice present. So a very interesting case, and one that you should take note of. So just to summarize, where documents contain purely commercial discussions on settlement, this may be a case for board meeting minutes or emails, these will not be protected by litigation privilege. I think we should also touch on waiver, and there's been some recent case law in respect of a waiver. It's widely perceived that reference in a disclosable document or pleading to the mere fact or effect of privilege material will not amount to a waiver, whereas reference to its content will. There's been a recent case of Mond versus Insolvency Practitioners Association 2023, so very recent, which considered the implications of making reference to only a small amount of privileged material. During that case, it was argued that privilege was waived only to a limited extent in respect of that privileged material, and it was for a specific purpose. What the case highlights is that if you waive your right to a small amount of privileged material, it can quite easily lead to the court ordering further disclosure of more privileged material relating to the same issue or transaction. As a result, you shouldn't, when drafting, cherry pick what material to waive. Always, if you're unsure, consult third-party external lawyers. But references to privileged material should be treated with extreme caution, as it could lead, as I say, to the courts ordering further disclosure in respect of the same issue. Finally, in respect of waiver in error, again, another recent case, there is a presumption that if documentation or correspondence has been disclosed, then it was disclosed correctly and there was an intention to disclose it. However, we're all humans and we all make mistakes. The very recent case of Flow Creek UK Limited dealt with waiver in error, and what it did, it confirmed that the courts can intervene to limit or prevent the use of privileged documents which have been disclosed in error. There are some reasons for the court to intervene, and they include fraud, but also obvious mistake. Now, how do we deal with obvious mistake? The disclosing party will need to show the court in witness evidence that the disclosure was in error and that the mistake was obvious. A party who has made a mistake, of course, needs to act as quickly as possible. If there again is a delay, then this will potentially change the court's intention to intervene and provide protection of privileged documents. So we've touched on legal professional privilege, a quick overview on legal advice privilege and litigation privilege, and some of the more recent cases that have come out this year. What I'll do now is hand over to my colleague, Annabel Barons, who will deal with joint and common interest privilege before I look to wrap up with some helpful tips. Over to you, Annabel.
Thanks, Bill. Hi, so I'm going to discuss joint and common interest privilege, which is something that you should consider alongside the general principles of privilege, which Phil's just been through. Joint and common interest privilege can arise where multiple parties have a right to assert privilege in the same documents. So if we move to joint privilege, this occurs where multiple parties have a joint retainer or a joint interest in legal advice. For example, where a company seeks legal advice on a matter and the directors also have an interest. And joint privilege can be used to enable a party to gain access to privileged information held by another party. A useful test to see if joint interest exists is whether the parties could have instructed the same lawyer. For example, a beneficiary of a trust may have a joint interest in documents obtained by a trustee where the beneficiary can show that he has a joint interest in the subject matter of the documents. This would not be the case where the trustee and beneficiary have opposing interests, as obviously their interests would then not be joint. For joint interest privilege to apply, the joint interest must have existed at the time that the communication came into existence, and the communication must have come into being for the purpose of or the furtherance of the joint purpose or interest. Next up, we have common interest privilege. This can arise in respect of communications between parties sharing the same interest, even in circumstances where there's no joint privilege. For example, neighbours might be complaining of a nuisance where it affects them both equally, but actually only one party is the claimant. Common interest privilege allows a party to voluntarily disclose a privileged document to a third party. And if documents are protected by common interest privilege, then obviously the privilege is not waived by the sharing of this information. The common interest may be in the subject matter of the privileged communication or in the litigation to which the document is connected and in respect of which the document was created. So some examples of where common interest privilege has been found to arise in various case law includes owners of adjoining houses complaining of a nuisance which affected both parties equally, and both had taken legal advice and shared the relevant documents, but only one party was the claimant. A company and its director, a principal and an agent, a parent company and a subsidiary, or an insurer and an insured party. Where this privilege arises, a privileged document will also attract privilege in the hands of the receiving party with the shared interest in the subject matter of the document if they have it within their control. However, this privilege is ordinarily limited to a protective interest rather than an assertive one, which enables the receiving party to refuse to give disclosure of other such documents to third parties outside of the shared interest. Deciding that parties have a common interest does not entitle one of them to demand access to any other privileged documents from the other party that they share the interest with. And importantly, if two parties, A and B, have a common interest in litigation against a third party, C, and then subsequently A and B fall out and litigate between themselves, neither A or B can claim privilege in the documents created and shared in relation to the earlier litigation against C. If you do decide that you have common interest and you like to share the documents, then you might decide that you'd enter into a common interest agreement. So if we just switch to the next slide.
It switched on my computer, Annabel. Can you not see it?
That's great. So if you decide that you have common interest, you enter into a common interest agreement or confidentiality undertakings. These have become more widely used in English proceedings as a measure to allow the sharing of material while protecting either party from losing privilege. If you do enter into one of these agreements, you should make it clear within these agreements or undertakings that the material you're referring to is privileged. The sharing of the material does not amount to a waiver to the world. The information is to be held in confidence, is not to be disclosed, further distributed or copied without the prior approval of the original party, and any documents are to be returned or destroyed once the purposes for which they've been shared has come to an end. While common interest privilege exists without these formal agreements in place, and the agreements themselves don't guarantee that you will retain the privilege, they do help to reduce the risk of privilege being waived or lost. And in practice, you may also find that you could benefit from the communications that entering into these agreements facilitate.
Thanks, Annabel. Sorry, I'm having IT gremlins here, so apologies if you can't quite see those slides there. I'm hoping everybody can see the slide that says practical tips. In conclusion, just some practical tips to take forward for everybody. Using contemporaneous documents wherever possible to evidence the purpose of the material documents. Just because, you can mark communications confidential and privileged, but this in itself isn't conclusive, but something that you may wish to do. Seeking to limit the volume of communications will limit the risk of inadvertent waiver or accidental waiver in a world of emails. That is easily done. So trying to seek to limit the volume of communications would be a sensible approach to take. I think we all need to ensure that the relevant stakeholders at certain levels understand the concept and importance of retaining privilege. I'm sure you likely have updates with those stakeholders, but that is something that you should do regularly if at all possible. We also need to be able to satisfy the court on any delays between the creation of the material document and communications and, say, the starting of proceedings or seeking counsel's advice. There has to be some sort of explanation as to the thought process as to the delays. We also, to avoid the risk of legal advice privilege not applying to advice, ensure that any business or commercial advice is not contained within the same communication setting out the legal advice. So it may be more work in separating out the documentation, but it will be easier in respect of claiming legal advice privilege, and also might save you having to do some lengthy redactions. And finally, one plug for my team and Boys Turner generally is that if you as in-house counsel have any concerns your communications may not be protected by legal professional privilege, then you should consider appointing an external legal advisor. And of course, Boys Turner are here to help in that regard if required. So that was a whirlwind stop of privilege. Hopefully it's helpful and touches on a number of points, or just generally refreshes the mind as to those important points of privilege. That's us. There are email addresses. If you wish to reach out to us for anything, please feel free to drop us an email and hopefully we'll be able to assist. Finally, my colleague Rowan Tilrell, who's the head of the dispute resolution team here at Boys Turner, will be doing a contract law update webinar on the 16th of November 2023. So if you're available, the invites will be sent out shortly. It'll be great if you could join us, and we'll continue to be doing webinars over the next year. Finally, there are all our details. Thank you very much for joining. A lot of you have joined this morning. Wishing you all the best, and look forward to speaking to you next time. Many thanks.